Hello, everyone. We're continuing with part two of this case. Justice Barrett concurring. As the principal opinion demonstrates, the most natural reading of the Emergency Economic Protection Emergency International Emergency Economic Powers Act does not encompass the power to impose tariffs. I write only to address Justice Gorsuch's concurrence regarding the major questions doctrine. To the extent that Justice Gorsuch attacks the view that common sense alone can explain all our major questions decisions, he takes down a straw man. I have never espoused that view. Rather, as I explain in my concurrence in Biden v. Nebraska, the major questions doctrine situates text in context and is therefore best understood as an ordinary application of textualism. Textualists, like all those who use language to communicate, do not interpret words in a vacuum. Instead, we use context, including background legal conventions, common sense, and constitutional structure, to ascertain a text's most natural meaning. Part of this context, as I have explained, is Article 1 of the Constitution, which vests Congress with all legislative powers. Obviously, the Constitution bears on the meaning of a statute enacted pursuant to it. Because Article 1 grants all legislative powers to Congress, the reasonable interpreter would expect Congress to make the big-time policy calls itself rather than pawning them off to another branch. To the extent that Justice Gorsuch also thinks that background legal conventions and constitutional structure inform the most natural reading of a statute, then we may not be very far apart. Our only disagreement may be over the level of clarity required before a particular interpretation can be deemed the most natural one. I understand Justice Gorsuch to require Congress always to speak precisely to any major power that it intends to give away. As I have said before, I think that other less obvious clues can do the trick. I do not see any such clues here. In fact, as the court explains, the clues we have point in the opposite direction. At times, though, Justice Gorsuch suggests that the purpose of the major questions doctrine is something other than to ascertain the most natural reading of a statute. For example, he writes that the doctrine serves to prevent highly resourceful members of the executive branch from assuming new power for themselves because men are not angels. But if the Constitution permits Congress to give the executive a particular power, who are we to get in the way? Does the judiciary really protect the Constitution by impeding the constitutional action of another branch? If Justice Gorsuch thinks that we should forego the most natural reading of a statute because it is preferable for Congress rather than the president to make big decisions, that way lies a lot of trouble for the textualist. Strong-form substantive canons instructing a judge to adopt an inferior but tenable reading, veer beyond interpretation and into policy making. And while the policy may be desirable or even constitutionally inspired, judges should hesitate to impose disciplining rules on Congress. As Justice Scalia lamented, whether these dice-loading rules are bad or good, there is also the question of where the courts get the authority to impose them. Can we really just decree that we will interpret the laws that Congress passes to mean less or more than what they fairly say? Granted, strong-form canons exist elsewhere in the law. I do not propose to abandon these canons, nor have I taken the position that adopting them necessarily exceeds the judicial power, but I am skeptical about adding new ones to the mix. And while the major questions doctrine has an impressive pedigree as an interpretive principle, this court has not yet, anyway, embraced it as a strong-form rule that imposes a clarity tax on Congress. Justice Gorsuch seems to disagree, pointing to a few late 19th and early 20th century cases. But these cases, like our modern ones, are consistent with my context-based approach. They focus on ascertaining, not shaping, what the statute in dispute communicates. I would not treat this evidence as precedent for a judicial flex. Justice Gorsuch proposes to do something new. The innovation is in significant tension with textualism, so I do not support the project. Justice Kagan, with whom Justice Sotomayor and Justice Jackson joined concurring in part and concurring in judgment. The court holds today that the International Emergency Economic Powers Act, IEPA, does not authorize the president to impose tariffs. I agree with that conclusion, as I do with the bulk of the principal opinion's reasoning. But because I think the ordinary tools of statutory interpretation amply support today's result, I do not join the part of that opinion invoking the so-called major questions doctrine. The question that part asks, similar to the one posed in other major questions cases, is whether the president can identify clear congressional authorization for his action. Here to impose tariffs under IEPA. The demand is for a clear statement, something more explicit or specific than the statutory basis that would ordinarily suffice to support executive action. The reason for that requirement, according to today's opinion, is that the executive has claimed an extraordinary power, one never asserted before, and having large-scale economic and political significance. I objected in the principal cases cited to the demand for a special brand of legislative clarity. In my view, the court used its clear authorization rule in those cases to negate expansive delegations Congress had approved. I explained there that the proper way to interpret a delegation provision is through the standard rules of statutory construction. That means, most concisely stated, reading text in context. More expansively put, it means examining a delegation provision's language, assessing that provision's place in the broader statutory scheme, and applying a modicum of common sense about how Congress typically delegates. The last of those inquiries includes consideration of whether Congress ever has before, or likely would, delegate the power the executive asserts, a matter also of import in applying the major questions doctrine. In the past, though, I have thought that the court used that doctrine to override rather than help discover the best reading of delegation statutes. This case presents more nearly the opposite situation. The use of a clear text statement rule here is unnecessary because ordinary principles of statutory interpretation lead to the same result. It is not just that the government's arguments fail to satisfy an especially strict test, it is that they fail to satisfy the normal one. Even without a clear statement rule in the picture, the conclusion follows. IEPA does not authorize the president to impose tariffs. And indeed, the principal opinion's reasoning well explains why. The rest of this opinion draws on that analysis, I hope without too much rehashing, to demonstrate that what I view as the fundamental point. Usual text-in-context interpretation dooms the tariffs the president has imposed. The crucial provision of IEPA, when viewed in light of the broader statutory scheme and with a practical awareness of how Congress delegates tariff authority, does not give the president the power he wants. More important, IEPA's key phrase, the one the government relies on, says nothing about imposing tariffs or taxes. The text authorizes the president, upon finding a foreign threat and declaring an emergency, to regulate the importation of foreign goods. And the meaning of regulate, both in common parlance and as Congress used the word, does not encompass taxing. To regulate, according to the government's preferred definition, means to fix, establish, or control, to adjust by rule, method, or established mode, to direct by rule or restriction, to subject to governing principles or laws. Nothing in that definition naturally refers to levying taxes, nor does Congress ever use the word regulate in that way. Hundreds of provisions in the U.S. Code give agencies the authority to regulate one thing or another. Yet the government cannot identify a single one that is understood to grant taxing power. When Congress wants to delegate that power, it uses a whole different vocabulary, terms like duty, tariff, or surcharge, which do not appear in IEPA. And likewise, when Congress means to cover both regulatory and taxing powers, it refers to each separately. Of course, Congress knows that taxing can be used for regulatory ends. They can be a means of controlling or adjusting behavior. But Congress still follows the path this court long ago marked out, and the one most consonant with ordinary meaning, of treating the power to regulate trade as entirely distinct from the powers to levy taxes. So in granting only the former, IEPA excludes the latter. The president has the ability to regulate, but not to impose taxes on imports. The surrounding statutory language confirms the point. As the principal opinion explains, regulate is one of 9 verbs listed in IEPA's delegation provision. The others are investigate, block, direct, compel, nullify, void, prevent, and prohibit. Those verbs are followed by 11 objects, each describing a distinct sort of transaction involving foreign property, not just importation, but also acquisition, use, transfer, and so forth. Combine the verbs and objects in all possible ways, and the statute authorizes 99 actions a president can take to address a foreign threat. And exactly none of the other 98 involve involves raising revenues. Rather, each enables the president to impose penalties, restrictions, or controls on foreign commerce. So when the phrase regulate importation is invoked to impose quantity or quality limits on bringing foreign goods into the country, for example, by setting quotas or requiring quantities or requiring quarantines, the phrases fit well with its 98 neighbors. Just like the rest, it provides a way to constrain or alter various foreign transactions. But when that phrase is invoked to impose tariffs, then it becomes the odd man out. The only one of 99 permission slips it to involve the core congressional power of the purse. So even if, contra both conventional and congressional usage, the word regulate might refer to taxation in some other hitherto undiscovered statutory context, it would not do so in IEPA. Likewise, Congress's consistent practice in delegating tariff power refutes the government's position. As the principal opinion details, Title 19 of the U.S. Code includes multiple provisions granting the president authority to levy tariffs. But in each and every instance, Congress has not only used specific language, but also imposed tight restraints on the power given. It has capped the tariff rates, for example 15%, or limited the tariff's duration, for example 150 days, or established strict procedural conditions before the tariff can take effect, for example investigations, public hearings, and reports, or all the above. What Congress has never done in a tariff provision is what the government claims it did here, conferring power on the president to impose a tariff of any amount for any time on only his own say-so. And construing IEPA to give that unparalleled authority would effectively erase all the carefully confined tariff provisions in Title 19. For any president could then escape the rigors of those laws, could put in place, say, a non-time limited 100% tariff on all foreign products by the simple expedient of identifying a foreign threat. That gutting of Title 19's tariff scheme is not what Congress, when delegating power to regulate imports, could have meant to accomplish. Nor has any president until now understood IEPA to authorize imposing tariffs. Between 1977, when IEPA was enacted, and 2024, 8 presidents had the chance to make use of IEPA's delegation of power, and all chose the same course. They invoked the statute's regulate importation provision for a variety of non-tariff purposes, but they looked elsewhere to Title 19's provisions for tariff authority. In other words, each president read the statutes as Congress wrote them, with IEPA enabling him to regulate imports and Title 19 enabling him, in confined situations, to tax those foreign goods, none as far as anyone has suggested even considered doing otherwise. For all those reasons, straight-up statutory construction resolves this case for me. I need no major questions thumb on the interpretive scales. IEPA gives the president significant authority over transactions involving foreign property, including the importation of goods. But in that generous delegation, one power is conspicuously missing. Nothing in IEPA's text, nor anything in its context, enables the president to unilaterally impose tariffs, and needless to say, without statutory authority, the president's tariffs cannot stand. Justice Jackson, concurring in part and concurring in judgment. I agree with the court's conclusion that the International Emergency Economic Powers Act, IEPA, does not provide the president with the power to tariff. 3 of my colleagues have reached this result via the major questions doctrine, a framing that asks, in essence, whether Congress would likely have intended to delegate the authority to tariff to the president through IEPA. While probing Congress's intent is the right inquiry, my colleagues speculate needlessly. In my view, the court can and should consult a statute's legislative history to determine what Congress actually intended the statute to do. As Congress undertakes the legislative process, congressional committees in the Senate and House often generate official reports to describe Congress's aims for the legislation. Indeed, there is evidence that lawmakers themselves pay more attention to these reports than a statute's text to understand the statute's purpose and meaning. Thus, in contrast to the principal dissent's rejection of committee reports as a means of ascertaining a statute's meaning, I think these Senate and House reports are among the best evidence of what Congress sought to accomplish with its enactments. In the cases now before us, the evidence shows that Congress did not intend for IEPA to authorize the executive to impose tariffs. Instead, Congress intended to delegate to the president the power to freeze and control foreign property transactions. 4 pieces of the relevant legislative record support this conclusion. The first 2 are the House and Senate reports that accompanied the 1941 amendment to IEPA's predecessor statute, the Trading with the Enemies Act, TWE. First enacted in 1917, TWE authorized the president to control foreign property during wartime, but some of TWE's sections delegating this authority had lapsed, and there was doubt as to the effectiveness of other sections. Accordingly, Congress amended TWE in 1941, adding the subsection that includes the regulate importation language on which the president relies today. Referencing First War Powers Act. The reports explained Congress's primary purpose for the 1941 amendment, shoring up the president's ability to control foreign-owned property by maintaining and strengthening the existing system of foreign property control. When Congress enacted IEPA in 1977, limiting the circumstances under which the president could exercise his emergency authorities, it kept the regulate importation language from TWE. The other two relevant pieces of legislative history, the Senate and House reports that accompanied IEPA, demonstrate that Congress's intent regarding the scope of the statutory language remained the same. As the Senate report explained, Congress's sole objective for the regulate importation subsection was to grant the president the emergency authority to control or freeze property transactions where a foreign interest is involved. The House report likewise described IEPA as empowering the president to regulate or freeze any property in which any foreign country or a national thereof has any interest. With this evidence of Congress's objective, interpreting the text of IEPA becomes an easy task. Each of the listed verbs, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit, provides a means by which the president can freeze or control foreign property transactions. Tariffs are different in kind. They are a tax on imports, a means of generating revenue from transactions between private parties. Because tariffs are not a means by which the president can freeze or control foreign assets, interpreting IEPA to authorize tariffs would require the court to override Congress's expressed purpose for including the regulate importation language in the statute. Like the Chief Justice's opinion, the principal dissent declines to the help of legislative history. The dissent concludes that IEPA and TWE are best understood as authorizing tariffs and that any other interpretation would not make much sense. But why would it matter which interpretation we think is best when Congress has already told us? The legislative history here plainly establishes that Congress understood and intended IEPA and TWE to authorize a wholly different type of power, the power to freeze foreign-owned property, and the proper role of the court is to give effect to Congress's intent, not our own instincts. In short, in these cases, the legislative history provides helpful evidence of what Congress was trying to do in IEPA. Given that evidence, we need not speculate or, worse, step into Congress's shoes and formulate our own views about what powers would be best to delegate to the president for use during an emergency. When Congress tells us why it has included certain language in a statute, the limited role of the courts in our democratic system of government as interpreters, not lawmakers, demands that we give effect to the will of the people. Justice Thomas dissenting. I join Justice Kavanaugh's principal dissent in full. As he explains, the court's decision today cannot be justified as a matter of statutory interpretation. Congress authorized the president to regulate importation. Throughout American history, the authority to regulate importation has been understood to include the authority to impose duties on imports. The meaning of that phrase was beyond doubt by the time that Congress enacted this statute, shortly after President Nixon's highly publicized duties on imports were upheld based on identical language. The statute that the president relied on therefore authorized him to impose the duties on imports at issue in these cases. Justice Kavanaugh makes clear that the court errs in concluding otherwise. I read separately to explain why the statute at issue here is consistent with the separation of powers as an original matter. The Constitution's separation of powers forbids Congress from delegating core legislative power to the president. This principle, known as the non-delegation doctrine, is rooted in the Constitution's legislative vesting clause and due process clause. Both clauses forbid Congress from delegating core legislative power, which is the power to make substantive rules setting the conditions for deprivations of life, liberty, or property. Neither clause prohibits Congress from delegating other kinds of power. Because the Constitution assigns Congress many powers that do not implicate the non-delegation doctrine, Congress may delegate the exercise of many powers to the president. Congress has done so repeatedly since the founding and with this court's blessing. The power to impose duties on imports can be delegated. At the founding, that power was regarded as one of many powers over foreign commerce that could be delegated to the president. Power over foreign commerce was not within the core legislative power, and engaging in foreign commerce was regarded as a privilege rather than a right. Early Congresses often delegated to the president power to regulate foreign commerce, including through duties on imports. As I suggested over a decade ago, the non-delegation doctrine does not apply to a delegation of power to make rules governing private conduct in the area of foreign trade, including rules imposing duties on tariffs. Therefore, to the extent that the court relies on separation of powers principles to rule against the president, it is mistaken. The non-delegation doctrine is rooted in both the legislative vesting clause and the due process clause. The doctrine ensures that the legislative branch cannot transfer the power of making laws to any other hands. Importantly, however, the non-delegation doctrine applies only to Congress's core legislative powers, not to all of its powers. The legislative vesting clause grants Congress alone the federal legislative power. It requires that all legislative powers granted to the federal government shall be vested in a Congress of the United States. It follows that those federal legislative powers cannot be exercised by anyone else, including the president. Legislative power, for purposes of the vesting clause, means the power to make substantive rules settings, the conditions for legislative power for purposes of the vesting clause means the power to make substantive rules setting the conditions for deprivations of life, liberty, or property. I have described this power as the core legislative power, to distinguish it from other powers that the Constitution grants Congress. Core legislative power includes only the power to make law, in the Blackstonian sense of generally applicable rules of private conduct, the violation of which results in the deprivation of core private rights. These core private rights are the natural rights of life, liberty, and property. The non-delegation doctrine is also rooted in the Due Process Clause. That clause prohibits the federal government from depriving any person of life, liberty, or property without due process of law. The founders modeled it on Chapter 39 of the Magna Carta, which prohibited the deprivation of a free man's private rights except by the lawful judgment of his peers and by the law of the land. By the founding, the Magna Carta was understood to mean that no subject would be deprived of a private right, that is, a right of life, liberty, or property, except in accordance with the law of the land, which consisted only of statutory and common law. A rule made by someone other than the legislature, such as the king, was not the law of the land. Chief Justice Coke famously held invalid the King's proclamation prohibiting new buildings in London because the court could not create any offense without Parliament. When the founders transplanted the same principle into the Due Process Clause, they ensured that when the government wanted to deprive the people of the familiar core private rights of life, liberty, and property, it could not do so on the basis of a rule or a will not enacted by the legislature. Neither the Legislative Vesting Clause nor the Due Process Clause forbids Congress from delegating its other powers, as this court put it 2 centuries ago. Although Congress cannot delegate powers that are strictly and exclusively legislative, it can certainly delegate others. Many of Congress's powers fall within the core legislative power subject to the non-delegation doctrine. For example, the Constitution gives Congress the power to regulate commerce among the states. Congress can thus make substantive rules for interstate trade, such as by restricting drug shipments across state lines, punishable with fines or imprisonment. Likewise, the Constitution gives Congress many other powers that implicate life, liberty, and property, including the power to provide for the punishment of counterfeiting, the power to provide for the punishment of treason, and the power to impose internal taxes. These powers cannot be delegated, as I have repeatedly explained. They cannot be delegated even if Congress delegates them unambiguously. Congress also has many powers that are not subject to the non-delegation doctrine. We now think of the powers listed in Article 1, Section 8 as quintessentially legislative powers, but many of them were actual, former, or asserted powers of the Crown, which the drafters decided to allocate to the legislative branch. These include the powers to raise and support armies, to fix the standards of weights and measures, to grant copyrights, to dispose of federal property, and, as discussed below, to regulate foreign commerce. None of these powers involves setting the rules for the deprivation of core private rights. Blackstone called them prerogative powers and sometimes executive. By one count, 13 of the 29 powers given to Congress in Article 1 were powers that Blackstone described as executive powers. For most of American history, the non-delegation doctrine was understood not to apply to these powers. The early Congresses felt free to delegate certain powers to President Washington in broad terms. Thus, the Constitution gives Congress the power to support armies, but Congress in 1789 delegated to the President the power to establish regulations for benefits to veterans wounded in the Revolutionary War. The Constitution gives Congress the power to grant patents, but Congress in 1790 delegated to executive officials the power to grant patents in their discretion. The Constitution gives Congress the power to borrow money, but Congress in 1790 delegated to the President the power to borrow up to $12 million on behalf of the United States in his discretion. The Constitution gives Congress the power to raise armies, but Congress in 1791 delegated to the President the power to raise an army of 2,000 troops at his discretion. And as I explained further below, the Constitution gives Congress the power to regulate foreign commerce, but early Congresses often delegated to the President the power to regulate foreign commerce. These early delegations had one thing in common. They did not implicate the legislative vesting clause or the due process clause. None of these statutes disturbed the natural rights or intruded into the core of the legislative power. They therefore did not violate the non-delegation doctrine. The Constitutional Convention seemed to agree with this understanding of delegation. James Madison proposed an amendment clarifying that the President has the power to execute such other powers as were delegated by the national legislature, so long as the delegated powers were not legislative nor judiciary in their nature. Thus, in Madison's view, some of Congress's powers were not legislative, but could be delegated to the President. Madison's proposal was rejected after others argued that it was unnecessary. Madison agreed that the purpose of the proposed amendment was only to prevent doubts and misconstructions. Nobody disputes that Madison stated the correct scope of the non-delegation doctrine. As a matter of original understanding, historical practice, and judicial precedent, the power to impose duties on imports is not within the core legislative power. Congress can therefore delegate the exercise of this power to the President. Neither of the two constitutional foundations for the non-delegation doctrine forbid Congress from delegating to the President the power to impose duties on imports. The legislative vesting clause provides no basis for applying the non-delegation doctrine to the power to impose duties on imports. The power over external affairs is in origin and essential character different from that over internal affairs. Although internal affairs are governed by the domestic law of one sovereign, external affairs implicate the relationship between sovereigns, which is subject to the laws of nations. External affairs, then, are not susceptible to being directed by antecedent, standing positive laws made by one nation. When a person goes abroad, he must resort to the political branches, and ultimately the military, rather than the judiciary for protection, can indebt the executive to foreign nations for his personal misconduct, and can trigger a foreign conflict. The power to regulate external affairs was accordingly not viewed as within the core legislative power at the founding. Blackstone described powers over intercourse with foreign nations as prerogative powers naturally belonging to the king. Locke agreed that this power must be lodged with the executive. Baron de Montesquieu classified all powers in respect to things dependent on the law of nations as part of the executive power. The legislative power, by contrast, applied only within the realm. The power to regulate external affairs included power over foreign commerce. At the founding, the external executive power included the transactions of the state with any other independent state. In Great Britain, the king had no unilateral legislative power, but he had much unilateral power over foreign commerce. His power over foreign commerce included the power to govern foreign trade, and to prohibit any of his subjects from leaving the realm. Thomas Rutherford's Institutes of Natural Law Institutes of Natural Law, a treatise routinely cited by the founders, explained that the external executive power included the power of adjusting the rights of a nation in the respect of trade. The power to impose duties on imports was a conventional method for governing trade. It originated as a prerogative right of the king. The Due Process Clause likewise provides no basis for applying the non-delegation doctrine to the power to impose duties on imports. The Due Process Clause protects rights, not privileges. Importing is a matter of privilege. The government can charge money for privileges without depriving a person of property for due process purposes. The government charges people money every day for a wide range of activities, such as to enter a government park, mail an envelope, apply for a copyright, or file a lawsuit. Because a person has no core private right to engage in these activities, the government is not subject to due process restraints in setting such charges. The due process question is not whether a government action raises revenue, but whether it implicates core private rights. Thus, when Congress delegates power to make regulations on federal land, the Secretary of Agriculture can set a charge for the privilege of grazing sheep on that land without thereby exercising the legislative power. Congress has, consistent with due process, delegated the power to set charges for a wide range of privileges. A person has no core private right to import goods at the founding. A person had no core private right to import goods at the founding. On the founders' understanding, statutes allowing importation of goods from abroad were thought to create mere privileges rather than core private rights. Foreign commerce was governed by the law of nations, which is a law of sovereigns, not of private individuals. Any attempt to introduce foreign goods without the expressed allowance of the sovereign was a violation of its sovereignty, quoting Cross v. Harrison. Every state had a right to prohibit the entrance of foreign merchandises, including through the imposition of duties on imports. Because no one had a vested right to import any goods from abroad, the imposition of tariffs as a condition for importing those goods did not implicate the Due Process Clause, any more than when the government charges money for other privileges. The power to impose duties on imports thus does not implicate either of the constitutional foundations for the non-delegation doctrine. Hence, even the strongest critics of delegation, myself included, have recognized that regulations of foreign commerce might not be subject to ordinary non-delegation limitations. So long as Congress complies with other constitutional limitations, it can delegate this power. Historical practice and precedent confirm that Congress can delegate the power to impose duties on imports. Since the 1790s, Congress has consistently delegated to the President power over foreign commerce, including the power to impose duties on imports. Practically every volume of the United States statutes contains broad delegations to the President in the area of foreign commerce. The first Congress gave the President the power to prescribe rules and regulations that would govern any person licensed to trade with Indians. Trade with Indians was regarded as a matter of external relations. In delegating this power, Congress did not specify or limit what kinds of regulations the President could impose. Pursuant to that broad delegation, the President restricted trading distilled spirits, required each trader to give intelligence to the government, and subdelegated to his superintendents the power to assign the limits within which each trader shall trade. Any person who violated the President's regulations would owe $1,000 payable to the President. Succeeding early Congresses delegated many more powers over foreign commerce to the President. In 1794, Congress delegated to the President the power to lay an embargo on all ships and vessels in the ports of the United States, including ships belonging to Americans, unless Congress was in session. It authorized the President to make such regulations as the circumstances of the case may require in exercising that delegated power. Congress allowed the President to impose the embargo as in his opinion the public safety shall so require. Congress delegated to the President the power to permit the exportation of arms, cannon, and military stores, the law prohibiting the exportation of the same to the contrary notwithstanding. In 1798, Congress delegated to the President the power to discontinue prohibitions and restraints on commerce with France. In 1799, Congress delegated to the President the authority to discontinue and to reimpose restraints and prohibitions on commerce with France when it deemed it expedient and consistent with the interests of the United States. Congress delegated to the President the power to remove a ban on trade with France and to reestablish certain restraints and prohibitions when he deemed it expedient. Congress likewise delegated to the President the power to set duties on imports. In 1815, Congress delegated to the President the power to lower reciprocal duties when he was satisfied that other nations' trade practices no longer operated to the disadvantage of the United States. In 1824, Congress delegated to the President the power to lower and to reimpose duties in response to foreign nations' trade practices. Throughout the early decades of the Republic, Congress continued to delegate to the President similar powers over duties on imports on a regular basis. Presidents frequently changed the rates of duties on imports as to various foreign nations pursuant to these delegations. This court has consistently upheld Congress's delegation of power over foreign commerce, including the power to impose duties on imports. The court has long conveyed to Congress that it it may invest the president with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Since shortly after the founding, the court has rejected challenges to delegations of power over foreign commerce. Even when a challenged delegation, if it were confined to internal affairs, would be invalid, the court has upheld the delegation. There is a fundamental difference, the court has explained, between foreign or external affairs and domestic or internal affairs. Thus, Congress may, of course, delegate very large grants of its power over foreign commerce to the president, including when it comes to imposing duties on imports. When Congress has delegated power to the president, the power to impose duties on imports, this court has upheld those delegations. In Clark, the court upheld Congress's delegation to the president of the power to impose duties on nations whose importation policies he may deem to be reciprocally unequal and unreasonable. It explained that Congress had frequently, from the organization of the government to the present time, conferred powers over trade and commerce to the president. In J.W. Hampton, Jr. and Company v. United States, the court upheld a delegation to the president and to impose duties as necessary to statutorily limited rates to make them reciprocal. And in Federal Energy Administration v. Algonquin, the court upheld a delegation of the power to impose a universal duty on imported oil. Although these cases involved duties on imports, the court nowhere suggests that a different non-delegation rule applied because the duty was a tax or raised revenue. Although these cases involved duties on imports, the court nowhere suggested that a different non-delegation rule applied because the duty was a tax or raised revenue. Congress's delegation here was constitutional. The statute at issue in these cases, the International Emergency Economic Powers Act, delegates to the president a wide range of powers over foreign commerce. IEPA gives the president, on conditions satisfied here, the power to regulate foreign commerce, including importation of foreign property. IEPA's delegation of power to impose duties on imports complies with the non-delegation doctrine. Congress delegated to the president a version of the same power that it has delegated to him in many statutes since the early days of the Republic. Congress limited that delegation to foreign commerce. In delegating the power to impose duties on imports, it gave the president no core legislative power to make substantive rules setting the conditions for deprivations of life, liberty, or property. Its delegation therefore complied with the constitutional separation of powers and is consistent with centuries of practice and precedent. It did not need to exercise that power itself, and did not need to delegate it unambiguously, even though, as Justice Kavanaugh explains, it did. The principal opinion bases its decision on the major questions doctrine. In some cases, the court has used the major questions doctrine as a canon of statutory interpretation because delegations of major powers are unlikely to be subtle. In other cases, the court has used it to avoid what would have been originally understood as an unconstitutional delegation of legislative power. In today's case, neither the statutory text nor the Constitution provide a basis for a ruling against the president. I respectfully dissent. Justice Kavanaugh, with whom Justice Thomas and Justice Alito joined dissenting, acting pursuant to his statutory authority to regulate importation under the 1977 International Emergency Economic Powers Act, or IEPA, the president has imposed tariffs on imports of foreign goods from various countries. The tariffs have generated vigorous policy debates. Those policy debates are not for the federal judiciary to resolve. Rather, the judiciary's more limited role is to neutrally interpret and apply the law. The sole legal question here is whether, under IEPA, tariffs are a means to regulate importation. Statutory text, history, and precedent demonstrates that the answer is clearly yes. Like quotas and embargoes, tariffs are a traditional and common tool to regulate importation. Since early in U.S. history, Congress has regularly authorized the president to impose tariffs on imports of foreign goods. Presidents have often used that authority to obtain leverage with foreign nations, help American manufacturers and workers compete on a more level playing field, and generate revenue for the United States. Numerous laws, such as the Trade Expansion Act of 1962 and the Trade Act of 1974, continue to authorize the president to place tariffs on foreign imports in a variety of circumstances. Presidents have often done so. In recent years, Presidents George W. Bush, Obama, and Biden have all imposed tariffs on foreign imports under those statutory authorities. President Trump has similarly imposed tariffs and has done so here under IEPA. During declared national emergencies, IEPA broadly authorizes the president to regulate international economic transactions. Most relevant for this case, during those national emergencies, IEPA grants the president the power to regulate importation of foreign goods. In early 2025, President Trump declared 2 national emergencies pursuant to the National Emergencies Act. One emergency concerned drug trafficking into the United States. The other emergency involved trade imbalances with foreign nations that have harmed American manufacturers and workers. To help address those emergencies, the president drew upon his authority in IEPA to regulate importation, and he imposed tariffs on imports from various countries. The plaintiffs argue, and the court concludes, that the president lacks authority under IEPA to impose tariffs. I disagree. In accord with Judge Taranto's careful and persuasive opinion in the Federal Circuit, I would conclude that the president's power under IEPA to regulate importation encompasses tariffs as a matter of ordinary meaning, including dictionary definitions and historical usage. The broad power to regulate importation includes the traditional and common means to do so, in particular quotas, embargoes, and tariffs. History and precedent confirm that conclusion. In 1971, President Nixon imposed 10% tariffs on almost all foreign imports. He levied the tariff under IEPA's predecessor statute, the Trading with the Enemies Act, which similarly authorized the president to regulate importation. The Nixon tariffs were upheld in court. Moreover, in 1976, a year before IEPA was enacted, this court unanimously ruled that a similarly worded statute authorizing the president to adjust the imports, permitting President Ford to impose monetary exactions on foreign oil imports. For both the Nixon tariffs and the Ford tariffs upheld by this court in Algonquin, the relevant statutory provisions did not specifically refer to tariffs or duties, but instead more broadly authorized the president to regulate importation or to adjust the imports. Therefore, when IEPA was enacted in 1977 in the wake of the Nixon and Ford tariffs and the Algonquin decision, Congress and the public plainly would have understood that the power to regulate importation included tariffs. If Congress wanted to exclude tariffs from IEPA, it surely would not have enacted the same broad regulate importation language that had been used to justify major American tariffs on foreign imports. Importantly, IEPA's authorization for the president to impose tariffs did not grant the president any new substantive power. Since the founding, numerous statutes have authorized and still do authorize the president to impose tariffs on other foreign import restrictions. IEPA merely allows the president to impose tariffs somewhat more effectively to deal with foreign threats during national emergencies. Context and common sense buttress that interpretation of IEPA. The plaintiffs and the court acknowledge that IEPA authorizes the president to impose quotas or embargoes on foreign imports, meaning that a president could completely block some or all imports. But they say that IEPA does not authorize the president to employ the lesser power of tariffs, which simply condition imports on a payment. As they interpret the statute, the president could, for example, block all imports from China, but cannot order even a $1 tariff on goods imported from China. That approach does not make much sense. Properly read, IEPA does not draw such an odd distinction between quotas and embargoes on the one hand and tariffs on the other. Rather, it empowers the president to regulate imports during national emergencies with the tools presidents have traditionally and commonly used, including quotas, embargoes, and tariffs. The court today nonetheless concludes otherwise and holds that IEPA does not authorize the president to impose tariffs to deal with the declared drug trafficking and trade deficit emergencies. But the court's decision is splintered. In today's 6-justice majority, 3 justices, Justice Sotomayor, Justice Kagan, and Justice Jackson, interpret IEPA not to authorize tariffs as a matter of ordinary statutory interpretation. I disagree for the reasons noted above and elaborated on at length in this opinion. 3 other justices, the Chief Justice, Justice Gorsuch, and Justice Barrett, lean on the major questions canon of statutory interpretation to resolve this case. That important canon requires clear congressional authorization for an executive action of major economic and political significance, particularly when the executive exercises an unheralded power. In my view, as I will explain, the major questions canon does not control here for 2 alternative and independent reasons. First, the statutory text, history, and precedent constitute clear congressional authorization for the president to impose tariffs under IEPA. In particular, throughout American history, presidents have commonly imposed tariffs as a means to regulate importation, so tariffs were not an unheralded power when Congress enacted IEPA in 1977 and authorized the president to regulate importation of foreign goods. Therefore, the major questions doctrine is satisfied here. Second, in any event, the court has never before applied the major questions doctrine in a foreign affairs context, including foreign trade. Rather, as Justice Robert Jackson summarized and remains true, this court has always recognized the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the president is to be governed. In foreign affairs cases, courts read the statute as written and do not employ the major questions doctrine as a thumb on the scale against the president. Although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. That is because numerous other federal statutes authorize the president to impose tariffs and might justify most, if not all, of the tariffs at issue in this case, albeit perhaps with a few additional procedural steps that IEPA as an emergency statute does not require. Those statutes include, for example, the Trade Expansion Act of 1962, the Trade Act of 1974, and the Tariff Act of 1930. In essence, the court today concludes that the president checked the wrong statutory box by relying on IEPA rather than another statute to impose these tariffs. In the meantime, however, the interim effects of the court's decision could be substantial. The United States may be required to refund billions of dollars to importers who paid the IEPA tariffs, even though some importers may have already passed on costs to consumers or others. As was acknowledged at oral argument, the refund process is likely to be a mess. In addition, according to the government, the IEPA tariffs have helped facilitate trade deals worth trillions of dollars, including with foreign nations from China to the United Kingdom to Japan and more. The court's decision could generate uncertainty regarding those trade arrangements. In any event, the only issue before the court today is one of law. In light of the statutory text, long-standing historical practice, and relevant Supreme Court precedents, I would conclude that IEPA authorizes the president to regulate importation by imposing tariffs on foreign imports during declared national emergencies. I therefore respectfully dissent. Before turning to the specifics of IEPA's text, history, and precedent, I briefly review several fundamental constitutional principles about the role of the three branches of the U.S. government with respect to this case. First, the plaintiff and their amici, echoed by the court, rhetorically emphasize that Article 1, Section 8 of the Constitution assigns Congress, not the President, authority over tariffs. That rhetoric is a red herring in this case because no one disputes the point. Everyone, including the President, agrees that Congress possesses constitutional authority over tariffs. The important principle here, as everyone also acknowledges, is that Congress may in turn authorize the President to impose tariffs. Indeed, since the beginning of the Republic, Congress has regularly empowered the President to order tariffs and other foreign imports restrictions under various circumstances. As noted above, many current federal laws continue to grant the President expansive tariff authority, including the Trade Expansion Act of 1962 and the Tariff Act of 1930. Neither the plaintiffs nor the court had suggested that the numerous laws granting tariff power to the president violate the Constitution's separation of powers. Second, and relatedly, the president does not claim unilaterally the authority to impose IEPA tariffs without congressional authorization or over a congressional prohibition. On the contrary, the president's argument recognizes that in exercising his statutory tariff power under IEPA, he must act within the scope of Congress's authorizations and abide by Congress's limitations. And the executive has further acknowledged that the judiciary maintains the final word in justiciable cases on whether Congress has authorized the president to impose those tariffs under IEPA. The president here contends only that Congress, by enacting IEPA in 1977, authorized the president to impose tariffs on foreign imports in declared national emergencies. It used the familiar vernacular of Justice Robert Jackson in Youngstown. The president argued that this case falls into Category 1, where the president is acting pursuant to an express or implied authorization of Congress. The president has not here asserted authority to impose IEPA tariffs in a peacetime emergency in a Youngstown Category 2 or 3 scenario. Third, Congress possesses a variety of tools to limit the president's tariffs, directly via new legislation or perhaps more readily by not approving annual appropriations necessary for the executive branch to continue to implement the tariffs. Importantly, the House, the Senate, and the President annually approve most appropriations. As a result, each House of Congress and the President independently possess de facto veto power over particular appropriations. Of course, many different appropriations items are usually considered and packaged together, so the negotiations can be complex. But the point stands, Congress is not a helpless bystander when it comes to the president's exercise of tariff authority under IEPA. In Congress, moreover, everything is related to everything else, as the saying goes. Members and committees of Congress possess substantial tools of leverage over the executive branch. Congress could, for example, wield its authority over oversight, legislation, confirmations, or appropriations to pressure the president to reduce or eliminate some or all of the IPA tariffs. In light of Congress's appropriations authority and its other robust powers, it is not correct to suggest, as the Chief Justice's opinion today elliptically does, that two-thirds majorities of both houses of Congress would need to pass a new legislation over a presidential veto in order to limit these IEPA tariffs, or more generally, to restrict the president's use of IEPA to impose tariffs. This case presents one straightforward question of statutory interpretation. Does Congress's explicit grant of authority in IEPA for the president to regulate importation of foreign goods in declared national emergencies authorize the president to impose tariffs? The answer is clearly yes. I begin as always with the statutory text. In 1941, a few days after Pearl Harbor, Congress first enacted the relevant language regulate importation in an amendment to the 1917 Trading with the Enemies Act, known as TWE. After that 1941 amendment, TWE authorized the president to regulate importation both during wartime and during peacetime national emergencies. Then, in 1977, Congress split TWE into two separate statutes. As relevant here, Congress amended TWE to authorize the president to regulate importation during wartime only, and Congress enacted a separate statute, IEPA, that granted the president the power to regulate importation during peacetime national emergencies. The relevant IEPA text authorized the president to regulate importation by means of instructions, licenses, or otherwise. As the term otherwise indicates, the broadly worded statute did not exclude tariffs or dictate any specific means of regulating importation. At the time of TWE's amendment in 1941 and IEPA's enactment in 1977, the ordinary dictionary meaning of regulate was to control, to adjust by rule, or to subject to governing principles or laws. Imposing tariffs on imports is clearly a way of controlling imports. Governing or directing imports according to rule, or more generally, subjecting imports to governing principles or laws. So the dictionary definitions amply demonstrate that tariffs are a means to regulate importation of foreign imports. Consistent with those dictionary definitions and statutory references, tariffs historically have been, and still are, a common means for the United States to regulate importation of foreign goods. In determining the ordinary meaning of regulate importation, the meaning of the related phrase regulate commerce is also instructive. That phrase has long been interpreted to encompass tariffs. Since the founding, the Constitution's assignment to Congress of the broad power to regulate foreign commerce has been understood to include tariffs on foreign imports. As Chief Justice Marshall explained, the right to regulate commerce, even by the imposition of duties, was not controverted. So too, Justice Story. The power to regulate commerce includes the power of laying duties to countervail the regulations and restrictions of foreign nations. And still more Story. To lay duties is a common means of executing the power to regulate commerce. James Madison likewise stated that it cannot be inferred that the power to regulate trade does not involve a power to tax it. Marshall, Story, and Madison made a formidable trio, and this court has long echoed the Marshall, Story, Madison understanding that tariffs regulate foreign commerce. The laying of a duty on imports, although an exercise of the taxing power, is also an exercise of the power to regulate foreign commerce. And again, even though the taxing power is a distinct power and embraces the power to lay duties, it does not follow that duties may not be imposed in the exercise of the power to regulate commerce. The contrary is well established. The plaintiffs and the court today seize on the word regulate in isolation and say that it does not encompass the power to tariff. But the relevant statutory phrase is regulate importation, and we must look to the meaning of the phrase as a whole as our precedents dictate. As I have explained, since the founding, tariffs on foreign imports have been a common means of regulating foreign commerce, including imports. Notably, under the court's reading of the word regulate, Marshall, Story, and Madison all erred by concluding that the power to regulate foreign commerce includes the power to impose tariffs on foreign imports. That seems dubious. If the federal government's constitutional power to regulate foreign commerce includes tariffs, and if the power to regulate importation is the power to regulate foreign commerce with respect to imports, as it plainly is, then IEPA's authorization for the president to regulate importation clearly encompasses tariffs. Historical usage and that textual syllogism further buttress the dictionary definitions and help establish that tariffs are a means to regulate importation. Perhaps even more significantly, when IEPA was enacted in 1977, Congress and the public clearly would have understood that the phrase regulate importation encompassed tariffs. We know as much not only because of the dictionary definitions and the traditional understandings of tariffs as a tool to regulate foreign imports. We also know as much because of tariffs imposed by two presidents and approved by federal courts, including the Supreme Court in the years shortly before IEPA's 1977 amendment. First, in 1971, President Nixon imposed 10% tariffs across the board on virtually all imports from every country in the world. Those imports were justified under IEPA's predecessor statute, the Trading with the Enemies Act, or TWE. Like IEPA now, TWE at that time authorized the president to regulate importation during national emergencies as well as wartime. And like IEPA now, TWE was not did not specifically use the words tariff or duty. The Nixon tariffs did not fly below the radar. On the contrary, President Nixon announced the worldwide 10% tariffs in a prime-time address to the nation on August 15, 1971. He imposed the tariffs as a tool to make certain that American products will not be at a disadvantage and that the product of American labor will be more competitive. President Nixon sought to remove the unfair edge that some of our foreign competition has, and he declared that when the unfair treatment is ended, the import tax will end. The Nixon tariffs applied to almost all imports of foreign goods into the United States, and the tariffs had no time to limit. To be sure, they did not end up lasting forever, but President Nixon terminated them only because the tariffs, as intended, induced major American trading partners to negotiate new agreements. The Nixon tariffs garnered substantial national and international attention and were generally popular in Congress. Predictably, however, the tariffs sparked litigation challenges. In 1975, the Court of Customs and Patent Appeals, the predecessor to the Federal Circuit, upheld the Nixon tariffs as a lawful exercise of the president's authority to regulate importation under TWE. The losing plaintiffs did not seek further review in this court. 2 years later, in 1977, when Congress divided TWE into two, the Congress retained the same regulate importation language in both laws, in TWE for wartime and in IEPA for peacetime and national emergencies. In doing so, members of Congress were plainly aware, after all, how could they not be, that the regulate importation language had recently been invoked by the president and interpreted by the courts to encompass tariffs. Indeed, the House Committee report noted that the relevant regulate importation provision in TWE came into play when, on August 15, 1971, President Nixon declared a national emergency with respect to the balance of payments crisis, and under that national emergency imposed a surcharge on imports. The report further referenced the appeals court's holding in Yoshida that TWE authorized impositions of duties because of the existence of the national emergency. The Nixon tariffs persuasively demonstrate that members of Congress and the public would have understood the phrase regulate importation to include tariffs when IEPA was enacted in 1977. If Congress wanted to exclude tariffs from IEPA's scope, why would it enact the exact statutory language from TWE that had just been invoked by the president and interpreted by the courts to cover tariffs? Neither the plaintiffs nor the court today offers a good answer to that question. Understandably so, because there is no good answer. The court tries to dodge the force of the Nixon tariffs by observing that one appeals court's interpretation of regulate importation to uphold Nixon's tariffs does not suffice to describe that interpretation as well settled when IEPA was enacted in 1977. Fair enough. But that is not the right question. The question is what members of Congress and the public would have understood regulate importation to mean when Congress enacted IEPA in 1977. Given the significant and well-known Nixon tariffs, it is entirely implausible to think that Congress's 1977 reenactment of the phrase regulate importation in IEPA was somehow meant to somehow meant or understood to exclude tariffs. Second, if one holds any lingering doubts about Congress's and the public's understanding of the power to regulate importation as of 1977, a second episode shortly before IEPA's enactment should answer them. In 1975, President Ford imposed significant monetary exactions on foreign imports of oil. He acted under Section 232 of the Trade Expansion Act of 1962. Like TWE and IEPA, the relevant provision of Section 232 did not use the word tariff or duty. Rather, Section 232 broadly authorized the president to adjust the imports of a product, language akin to the regulate importation language in IEPA and TWE. In contrast to the Nixon tariffs, the Ford tariffs on oil imports generated some pushback in Congress, and a group of utility companies and states quickly sued, arguing that the relevant statutory phrase, adjust the imports, did not authorize monetary exactions such as tariffs. Over a dissent, the D.C. Circuit agreed with the plaintiffs challenging the Ford's tariffs. Much like the court's decision today, the D.C. Circuit in the Ford matter concluded that Congress must explicitly authorize monetary exactions and that the applicable statutory phrase, adjust the imports, did not do so. In 1976, the Ford tariffs came to the Supreme Court. In this court, the plaintiffs pressed nearly identical arguments and rhetorical flourishes as those advanced by the plaintiff and repeated by the court in today's case. The plaintiffs argued that the Ford-imposed monetary exactions involved the broadest exercise of the tariff power in the history of the American Republic, reminiscent of George III's stamp tax. They contended that the statute's authorization for the president to adjust the imports did not allow for such monetary exactions because the statute did not mention the tariff on its face. They asserted that this court has never implied a tax, never in the history of this court, from language which does not explicitly provide for the tax. And here there is no such language. There is no language that mentions a measure of tax nor a method of calculation of tax. There is no such thing. They echoed the D.C. Circuit's holding that reading the phrase adjust the imports to encompass tariffs would be an anomalous departure from the consistently explicit, well-defined manner in which Congress has delegated control over foreign trade and tariffs. And they claimed that interpreting the statute to include fees undermines the whole tariff structure of the United States. Importantly, the Algonquin plaintiffs acknowledged, as do the plaintiffs and the court in today's case, that the statutory language adjust the imports would allow the president to impose quotas and embargoes on foreign imports. So a president could completely block all imports or limit their quantity. But according to the plaintiffs, Congress's adjust the imports language precluded the president from exercising the lesser power of imposing monetary exactions such as tariffs. The Supreme Court decided the Ford tariffs case in 1976. The court unanimously reversed the D.C. Circuit and flatly rejected the plaintiffs' arguments. The court held that the statutory phrase adjust the imports, even though it did not include the terms such as tariff, tax, duty, or fee, granted President Ford the authority to impose not only quotas and embargoes, but also monetary exactions on foreign imports. The court analyzed the statutory text and found no support in the language of the statute for the plaintiff's argument that adjust the imports should be read to encompass only quantitative methods, quotas as opposed to monetary methods, license fees of affecting such adjustments. The court further explained, unless one assumes, we do not, that quotas will always be a feasible method of dealing directly with national security threats posed by the circumstances under which imports are entering the country, limiting the president to the use of quotas would effectively and artificially prohibit him from directly dealing with some of the very problems against which subsection 232B is directed. In short, according to the unanimous Algonquin Court, the statutory text, structure, and logic of Section 232 definitively established that the President's authority to adjust the imports encompassed not only quotas and embargoes, but also monetary exactions such as tariffs and fees. Today's case should follow a fortiori from Algonquin. No meaningful daylight exists between the statutory phrase adjust the imports in Section 232 at issue in Algonquin and the phrase regulate importation in IEPA at issue here. The plaintiffs and the court in this case do not even try to distinguish adjust the imports from regulate importation, nor could they. Recall that the dictionary definition of regulate includes adjust by rule. To adjust imports is to regulate imports. Indeed, if anything, the phrase regulate importation is broader in scope than the phrase adjust the imports. So if Section 232's adjust the imports includes tariffs, as this court unanimously concluded in Algonquin in 1976, just a year before IEPA, how can IEPA's regulate importation not include tariffs? Algonquin's importance for today's case rests not merely on its status as a unanimous on-point Supreme Court statutory precedent, although it is surely significant for that reason as well. The case is especially consequential for present purposes because it helps show the ordinary public and congressional understanding of regulate importation in 1977 when Congress enacted IEPA. To be clear, the question here is not what individual members of Congress might have subjectively intended in 1977. The question is the ordinary meaning and understanding of the words that Congress used. Given that the phrase adjust the imports, again, in a statutory provision that did not use specific words such as tariff or duty, was unanimously held by this court in 1976 to include tariffs, and given that President Nixon had similarly relied on his statutory authority to regulate importation, to impose 10% tariffs on virtually all imports from all countries, could a rational citizen or member of Congress in 1977 have understood regulate importation in IEPA not to encompass tariffs? I think not. Any citizens or members of Congress in 1977 who somehow thought that the regulate importation language in IEPA excluded tariffs would have had their heads in the sand. The court today tries its best to distinguish Algonquin on the grounds that Section 232 included sweeping language authorizing the president to take such action that he deems necessary, where IEPA does not. But the Algonquin court did not rely on that language and instead focused on whether the phrase adjust the imports included monetary exactions. Moreover, IEPA itself broadly authorizes the president to regulate importation by means of instructions, licenses, or otherwise in order to deal with an unusual or an extraordinary foreign threat to the national security, foreign policy, or economy of the United States. That language is similarly expansive, authorizing the president to employ various tools to regulate importation. In short, just as the phrase adjust the imports includes tariffs, as Algonquin held, so too the phrase regulate importation includes tariffs. The court also attempts to brush aside Algonquin by citing an entirely different provision from the Trade Expansion Act, one that was not at issue in Algonquin, that expressly refers to a duty. But the Algonquin court did not rely on or even mention that provision when concluding that the statutory phrase adjust the imports includes tariffs, for good reason. That provision, which states that no action shall be taken to decrease or eliminate an existing duty or other import restriction, concerns only the power to reduce existing tariffs and plainly does not bear on a president's power to impose tariffs under Section 232. To sum up on the Nixon and Ford tariffs, when enacting IEPA in 1977, Congress employed the exact language recently invoked by President Nixon to justify 10% worldwide tariffs, and IEPA came fast on the heels of this court's unanimous 1976 decision in Algonquin, which held that substantially similar adjust the imports language authorized President Ford's tariffs on oil imports. Importantly, moreover, the statutory provisions authorizing the Nixon and Ford tariffs did not use specific words such as tariff or duty. The Nixon and Ford tariffs, this court's decision in Algonquin, and the ordinary and historical understanding of tariffs as a means of regulating imports together render it all but impossible to conclude that Congress in 1977 implicitly excluded tariffs when retaining TWE's regulate importation language in IEPA. If Congress in 1977 wanted to exclude tariffs from the president's IEPA toolkit, either it would not have retained the phrase regulate importation, or it would otherwise have made it clear in IEPA that the power to impose tariffs was excluded. Congress did neither. Two additional historical points strongly reinforce that analysis of text and precedent and further demonstrate that regulate importation and IEPA encompasses tariffs. First, U.S. history from the 1800s through IEPA's 1977 enactment illustrates how the statute came to incorporate the president's long recognized authority to impose tariffs during wartime and then also during peacetime national emergencies. Long before the initial 1917 enactment of the Trading with the Enemies Act, which was IEPA's predecessor, the president possessed inherent wartime authority to prohibit commercial relations with enemy nations. That inherent authority included the power to impose tariffs on foreign imports. For example, during the Mexican-American War in the 1840s, President Polk permitted only limited trade with Mexico subject to tariffs. Some members of Congress publicly questioned whether the president possessed that tariff authority. In response, President Polk justified the tariffs on the ground that the military right to exclude commerce altogether from the ports of the enemy and our military occupation included the minor right of admitting it under prescribed conditions. In 1854, the Supreme Court agreed with President Polk's view, stating, "No one can doubt that the President, as Commander-in-Chief of our naval forces, possessed the authority to regulate import duties." In 1862, President Lincoln partially lifted an existing blockade against the Confederate States during the Civil War. Like President Polk, he then permitted limited trade subject to a monetary fee. A group of cotton sellers later sued, arguing that the fee was essentially a tax and not authorized by any act of Congress, which alone had the power to impose taxes. The Supreme Court rejected that argument, holding that there was no question that requiring a monetary fee to trade with the Confederate States was part of the war power of the United States government. The existence of war meant a suspension of commercial intercourse between the opposing sections of the country, so if such a course of dealing were to be permitted at all, it would necessarily be upon such conditions as the government chose to prescribe. And in 1898, during the Spanish-American War, President McKinley imposed duties upon the occupation of any forts and places in the Philippine Islands. This court subsequently recognized those McKinley duties as a lawful wartime measure. Why does that wartime history matter? Because when Congress first enacted the Trade with the Enemies Act in 1917 during World War I, it statutorily codified some of the president's long-standing inherent wartime powers over foreign trade, which included the power to tariff. For the duration of World War I, Twee authorized the president, when he found the public safety so requires, to make it unlawful to import into the United States from any named country certain goods except at such time or times and under such regulations or orders, and subject to such limitations and exceptions as the president shall prescribe. In 1933, during the Great Depression and 5 days after President Franklin Roosevelt took office, Congress expanded Twee to apply not only in wartime, but also during a national emergency declared by the president. 8 years later, in 1941, a few days after Pearl Harbor, Congress again amended Twee's language by more succinctly providing that the president may regulate certain transactions, including importation under Twee during war or any other period of national emergency declared by the president. So as of 1941 and from then on to 1977, Twee expressly authorized the president to regulate importation both during wartime and during peacetime national emergencies. Historically, presidents had regulated importation by imposing tariffs, such as Polk, Lincoln, and McKinley tariffs illustrated. During that period, as I have discussed at length above, President Nixon in 1971 imposed 10% tariffs on almost all imports of foreign goods, and it relied on Twee's regulate importation language to justify them. Those tariffs were upheld in court. Then in 1977, Congress amended Twee and divided it into two statutes. Twee retained the president's power to regulate importation, but only during wartime. The newly enacted second law, IEPA, also retained the power to regulate importation, and it would apply during periods of declared national emergencies. As this court has previously recognized, IEPA was directly drawn from Twee, and the relevant authorities are essentially the same. Therefore, IEPA's specific language, regulate importation, was not new statutory text when Congress enacted IEPA in 1977. Far from it. But beginning in 1941, Twee had already authorized the president to regulate importation of foreign goods in wartime and national emergencies. And the earlier Polk, Lincoln, and McKinley examples, as well as the later Nixon example, demonstrated that the power to regulate importation historically encompassed tariffs as well as quotas and embargoes. The plaintiffs and the court today assert that wartime precedents do not govern peacetime, but Congress modeled IEPA on Twee precisely so that the president could continue to exercise certain wartime authorities such as quotas, embargoes, and tariffs during peacetime national emergencies as well. Congress first explicitly extended that wartime power to national emergencies in 1933, during the Franklin Roosevelt administration. And Congress has continued to authorize the president to exercise that power in both wartime and peacetime emergencies. In short, Congress in 1977 enacted the same regulate importation language that had long been understood to encompass tariffs. Second, contrary to the tenor of the plaintiffs and the court's arguments here, it would not have been at all unusual, or surprising for Congress when enacting IEPA in 1977 to authorize the president to impose tariffs. Since the early days of the Republic, Congress has regularly granted the president the power to regulate foreign trade, including via tariffs. A few examples. In 1810, Congress authorized the president to prohibit imports from Great Britain or France if either nation violated the neutral commerce of the United States. In 1890, Congress granted the president the power to impose import duties in response to duties imposed by other countries on American exports. In 1922, Congress empowered the president to levy import duties under certain conditions. In 1930, Congress enacted Section 338 of the Tariff Act, which authorizes the president to impose tariffs when he finds that any foreign country places any burden or disadvantage upon the commerce of the United States. In 1962, Congress authorized the president in Section 232 of the Trade Expansion Act to adjust the imports of a foreign good that threatens to impair national security. In 1974, under Section 201 of the Trade Act, Congress granted the president the power to take all appropriate and feasible action within his power, including imposing a duty on imports that, according to the U.S. International Trade Commission, have caused or threatened serious injury to a domestic industry. So, too, Section 301 authorizes the president to direct the U.S. Trade Representative to impose duties on countries engaging in unfair trade practices. In Section 122 of the Act, grants the president the power to impose a temporary import surcharge to deal with large and serious United States balance of payment deficits. Those many statutes definitively establish that Congress, since near the founding, had delegated to the president broad powers to impose tariffs on foreign imports. So it would hardly have been unusual or surprising for Congress to have granted tariff power to the president during wartime and peacetime national emergencies, as it did in TWE and IEPA. To be sure, given those other statutes that authorize the president to impose tariffs on foreign imports, one might reasonably ask, why did the president need distinct tariff authority under IEPA during peacetime emergencies, or for that matter, under TWE during wartime? The basic answer is that IEPA is an emergency statute that allows the president to impose tariffs somewhat more quickly, as would be expected in a declared national emergency. Similarly, in wartime, TWE allows the president to impose tariffs more rapidly. But critically, TWE and IEPA do not authorize the president to exercise some new substantive power. Rather, they authorize the president to exercise a commonly granted power, tariffs, more effectively than under the many ordinary tariff statutes. The plaintiffs and the court assert that interpreting IEPA to authorize tariffs would in effect evade specific limits on tariffs in certain other tariff statutes. But as Judge Taranto explained in the Federal Circuit, Congress and IEPA understandably afforded the president more flexibility to act during declared emergencies, just as Congress has done in TWE for wartime since 1970. Moreover, IEPA is not a blank check. IEPA contains its own limitations, including the requirement that the tariffs deal with an unusual and extraordinary foreign threat, a default one-year limit on emergencies, an enumerated list of exceptions, and comprehensive congressional reporting requirements. And as noted above, each House of Congress possesses a variety of tools to revoke, limit, or influence a president's IEPA or TWE tariffs. Relatedly, it is also not surprising that the many ordinary tariff statutes expressly refer to tariffs, duties, and the like, while IEPA and TWE do not, as Judge Taranto astutely explained. Congress in those statutes was overwhelmingly focused on tariff issues, whereas Congress in IEPA, as in TWE, was focused on the subject of emergencies and giving plainly broad emergency authority regarding foreign property. In sum, in authorizing the president to regulate importation, IEPA embodies an eyes-open congressional grant of broad emergency authority in this foreign affairs realm, which unsurprisingly extends beyond authorities available under non-emergency laws, and Congress confirmed the understood breadth by trying IEPA's authority to particularly demanding procedural requirements for keeping Congress informed. Finally, all of that text, history, and precedent is further reinforced by two compelling pieces of context. First, interpreting IEPA to exclude tariffs creates nonsensical textual and practical anomalies. The plaintiffs and the court do not dispute that the president can act in declared emergencies under IEPA to impose quotas or even total embargoes on all imports from a given country. But the president supposedly cannot take the far more modest step of conditioning those imports on payment of a tariff or duty. Textually, however, if quotas and embargoes are a means to regulate importation, how are tariffs not a means to regulate importation? Nothing in the text supports such an illogical distinction, and it does not make much sense to think that IEPA allows the president in a declared national emergency, for example, shut off all or most imports from China, but not to impose even a $1 tariff on imports from China. As Judge Toronto forcefully pointed out in the Federal Circuit, tariffs are just a less extreme, more flexible tool for pursuing the same objective of controlling the amount or price of imports that, after all, could be barred altogether. All of that explains why this court in Algonquin definitively rejected such a strange slice and dice approach to the president's statutory power to adjust imports. If quotas and embargoes are authorized, so are tariffs. In short, whether through prohibiting imports via embargoes or regulating the quantity of imports through quotas or regulating the prices of imports with tariffs, Congress granted the president flexibility in declared national emergencies to take various actions affecting imports of foreign goods. The plaintiffs and the court have no coherent textual or commonsensical explanation for why a rational Congress would, in such a momentous and carefully considered statute as IEPA, grant the president power to impose quotas and embargoes, but not tariffs, on foreign imports during emergencies. Second, IEPA was not debated and passed in a vacuum in 1977. It was enacted around the same time that Congress significantly constrained executive power in multiple ways in the wake of Watergate and Vietnam. The list of major new statutory restrictions on presidential power enacted in the 1970s is long and extraordinary, with lasting effects to the present day. And Congress, during that comprehensive examination and recalibration of government power, did not overlook TWE and the president's emergency authorities. Led by Senators Church and Mathias, Congress carefully studied the president's emergency authorities, including TWE. Then, in 1976 and 1977, Congress enacted a variety of legislation to tighten up the president's emergency powers, including by passing a new National Emergencies Act that cabined the president's authority to declare emergencies by setting forth various procedural requirements. Yet, when enacting IEPA in 1977, Congress continued to grant the president the power to regulate importation in declared national emergencies, a power that the president has possessed since 1941 under TWE, and that had recently been invoked by President Nixon to justify his 1971 tariffs. In IEPA and TWE in 1977, Congress consciously balanced concerns about expansive exercises of emergency powers against the necessity of equipping the president with tools to address exigencies that are difficult, if not impossible, to foresee. That broader congressional context, general skepticism, and scaling back of executive power, combined with reenactment of the familiar regulate importation language in IEPA, strongly indicates that Congress said what it meant and meant what it said when it enacted IEPA and continued to authorize the president to regulate importation during national emergencies. In an ordinary statutory interpretation case, I am confident that a majority of this court would flatly reject the plaintiff's exceedingly weak statutory arguments and would hold that IEPA's authorization for the president to regulate importation during national emergencies includes the power to tariff. Notably, the court today does not claim that the phrase regulate importation on its own excludes tariffs as a matter of ordinary statutory meaning. Only 3 members of the court, Justice Sotomayor, Justice Kagan, and Justice Jackson, do so. The Chief Justice's opinion in Parts 2A2, which is joined only by Justice Gorsuch and Justice Barrett, instead relies on the Major Questions Doctrine. The Major Questions Doctrine is an important canon of statutory interpretation that the court has applied in a number of significant cases over the last 45 years. Justice Scalia articulated the canonical statement of the Major Questions Doctrine. We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. Stated otherwise, in cases where the executive branch takes an action of major economic and political significance, it must point to clear congressional authorization for the power it claims. The requirement of clear congressional authorization for executive actions of major economic and political significance is grounded in two overlapping and reinforcing presumptions. 1. A separation of powers based presumption against the delegation of major lawmaking authority from Congress to the executive branch, and 2. A presumption that Congress intends to make major policy decisions itself, not leave those decisions to agencies. As this court later recounted in West Virginia, both separation of powers principles and a practical understanding of legislative intent makes us reluctant to read into ambiguous statutory text the delegation claimed to be lurking there. The doctrine guards against unintentional, oblique, or otherwise unlikely delegations of the legislative power. I agree that this case involves an executive action of major economic and political significance, which is typically the trigger for requiring clear congressional authorization. But in my respectful view, the Chief Justice's opinion's application of the major questions doctrine in this case is incorrect for two alternative and independent reasons. First, the statutory text, history, and precedent constitute clear congressional authorization for the president to impose tariffs as a means to regulate importation. Second, and in the alternative, the major questions doctrine does not apply in the foreign affairs context. In the foreign affairs realm, courts recognize that Congress often deliberately grants flexibility and discretion to the president to pursue America's interests. In that context, courts therefore engage in routine textualist statutory interpretation, reading the text as written, and do not employ the major questions doctrine as a thumb on the scale against the president. Because the major questions doctrine demands clear congressional authorization, this court has repeatedly recognized that the doctrine is distinct from routine statutory interpretation. Importantly, therefore, the doctrine applies and makes a meaningful difference only in cases where the executive's reading of a statute would, under more ordinary circumstances, be upheld. To properly set up the inquiry, a major questions issue arises when 1. The executive relies on the text of a generally worded statute to exercise a specific power of major economic and political significance. 2. The generally worded statute does not explicitly mention the specific major power. But 3. The asserted major power falls within the generally worded text of the statute, such that the executive's assertion of that power would, under more ordinary circumstances, be upheld. The question then is whether the generally worded statute supplies clear congressional authorization for the executive to exercise that specific but not explicitly mentioned major power. Here, for example, does the generally worded statutory authorization for the president to regulate importation clearly authorize the president to impose tariffs? The requirement of clear congressional authorization is enough to state, but how do we apply it? How do we decide in a particular case whether a generally worded statute actually constitutes clear congressional authorization for a major power that otherwise falls within the general terms? For starters, and critically, the court has repeatedly emphasized that the major questions doctrine is not a magic words requirement. In other words, the doctrine does not require an explicit reference to the specific major power itself. As the court's cases amply demonstrate, the major questions doctrine does not force Congress to delegate in highly specific terms. Rather than require magic words such as the words tariff or duty here, the court's cases have focused on four somewhat overlapping factors or considerations in order to assess whether a generally worded statute constitutes clear congressional authorization for the specific major power. First, the major questions doctrine's most prominent work has been to ensure that the executive cannot suddenly seize on an old and generally worded statute to exercise a power of great economic and political significance when that power would not reasonably have been understood at the time of enactment to fall within that generally worded statute. As the court has said, when an agency claims to discover in a long extent statute an unheralded power to regulate a significant portion of the American economy, we typically greet its announcement with a measure of skepticism. The doctrine thus precludes an agency's attempt to effectuate a fundamental revision of the statute. Stated otherwise, an agency's attempt to deploy an old statute focused on one problem to solve a new and different problem may be a warning sign that it is acting without clear congressional authorization. The court's skepticism about major executive action in those scenarios has been heightened when Congress has conspicuously and repeatedly declined to enact legislation that would have authorized the executive action in question. A prototypical example occurred when OSHA, in order to justify a nationwide COVID-19 vaccine mandate, nationwide COVID-19 vaccine mandate for workers relied on a statutory provision that was adopted 40 years before the pandemic and that focused on conditions specific to the workplace. Another example arose when the EPA invoked newfound authority to regulate emissions for millions of small sources, including retail stores, offices, apartment buildings, shopping centers, schools, and churches. Yet another happened when the CDC tried to impose an eviction moratorium for rental housing through an unprecedented assertion of its authority to regulate public health. Second, courts examine the agency's past interpretations of the relevant statute. The executive's track record can be particularly probative in the major questions context. A contemporaneous and long-held executive branch interpretation of a statute is entitled to some weight. Just as established practice may shed light on the extent of power conveyed by general statutory language, so the want of assertion of power by those who presumably would be alert to exercise it is equally significant in determining whether such power was actually conferred. The NFIB court therefore found it critical that OSHA, in its half-century of existence, has never before adopted a broad public health regulation of this kind, under the statute that the agency sought to invoke as authority for the vaccine mandate. Likewise, in Brown and Williamson, the FDA has repeatedly and consistently asserted that it lacks jurisdiction under the FDCA to regulate tobacco products. And in West Virginia, EPA had not previously interpreted the relevant provision to confer on it such a vast authority to transform American industry. Third, courts assess whether there is a mismatch between an agency's challenged action and its congressionally assigned mission and expertise. In other words, when an agency is trying to regulate outside its wheelhouse. In the NFIB case, OSHA, which is empowered to set workplace safety standards, not broad public health measures, mandated COVID-19 vaccines. In Alabama Association of Realtors, the CDC, a public health agency, attempted to regulate housing. In Gonzales v. Oregon, the Attorney General sought to assert authority over the drugs used in physician-assisted suicide. All of those cases involved serious mismatches between the agency's usual regulatory activities and its asserted major power. Fourth, the court looks at whether the relevant statutory language used to justify the executive's exercise of a major power is oblique, elliptical, or cryptic. As the court has often said, Congress does not hide elephants in statutory mouse holes. In MCI Telecommunications Corp., for example, the court refused to allow the FCC to eliminate rate regulation and fundamentally overhaul the telecommunications industry based on a subtle provision that merely permitted the FCC to modify rate filing requirements. In Brown and Williamson, the court rejected the FDA's attempt to regulate the tobacco industry based on a cryptic statutory provision that referred to safety. In Gonzales, the court said that Congress would not have granted the Attorney General the power to regulate physician-assisted suicide through oblique statutory language. And in West Virginia, the court found it unlikely that Congress would have granted major power to reshape the energy industry in a previously little-used backwater of the statute. So in this case, we must apply those four factors in order to determine whether Congress, when it afforded the president the power to regulate importation, clearly authorized the president to impose tariffs. As I see it, those factors show that Congress clearly authorized tariffs in IEPA when it empowered the president to regulate importation. First, unlike the OSHA vaccine mandate in NFIB or the greenhouse gas regulation in utility air, for example, the president here is not exercising an unheralded or newfound authority based on a long extant statute that is exercising a power that was unanticipated or unforeseen when Congress enacted IEPA's regulate importation language in 1977. On the contrary, as was fully explained above, the tariff authority exercised here is not remotely unheralded. To recap, any citizen or member of Congress who paid the least bit of attention in 1977 would have readily understood that the president's authority to regulate importation encompassed the power to tariff. There are the dictionary definitions of the historical usage and practice, and among other things, just a few years before IEPA, that regulate importation language was invoked by President Nixon and judicially approved to sustain his 10% worldwide tariffs. President Ford then implemented significant tariffs using substantially similar adjust the imports statutory language, and this court unanimously upheld President Ford's tariffs in Algonquin. So IEPA's grant of authority to the president to impose tariffs in order to regulate importation is not unheralded or newfound. That authority was plain as day in 1977. Second, the president is not interpreting the regulate importation language in IEPA differently from how past presidents have interpreted it. At least as far as the briefing and arguments in this case have disclosed, no presidential administration since the enactment of the regulate importation language in TWE in 1941 or since its reenactment in IEPA in 1977 has interpreted the statute to exclude the power to impose tariffs. Moreover, before IEPA's enactment, President Nixon imposed tariffs based on the same regulate importation language. And in 1975, President Ford invoked authority to adjust the imports in order to similarly impose monetary exactions. In addition, if more is needed, Marshall, Story, Madison, and this court have all long recognized that the power to regulate foreign commerce includes tariffs. The current president's reading of IEPA follows from its the current president's reading of IEPA follows from and is entirely consistent with those past interpretations, making his position nothing like, for example, FDA's when it changed its long-standing position that it lacked the authority to regulate cigarettes, or OSHA's when it implemented a vaccine requirement even though it had never before adopted a broad public health regulation of this kind. When, as here, established practice and the executive's track record convincingly show that the general statutory language has long been understood to cover the specific power asserted by the executive, that record should all but resolve the matter for major questions purposes. Third, there is no mismatch. The power to tariff falls squarely within the president's wheelhouse. From the founding, as the Chief Justice opinion today acknowledges, numerous other statutes have afforded and still do the president's broad power to impose tariffs. This case is entirely different, therefore, from our prior major questions cases where, for example, the CDC attempted to impose an eviction moratorium. OSHA sought to implement a nationwide vaccine mandate. The FDA tried to regulate cigarettes, and the Attorney General attempted to regulate physician-assisted suicide. Presidents imposing tariffs, whether pursuant to inherent wartime authority, pursuant to TWE and IEPA's regulate importation language, pursuant to Section 232's adjust the imports text, or pursuant to the many other tariff statutory authorities, is hardly an unusual occurrence in our nation's history or in recent times. For example, Presidents George W. Bush, Obama, and Biden all imposed tariffs pursuant to congressional authorization. There is no mismatch between the tariff power and the president's mission and expertise. Fourth, the president is not relying on oblique, elliptical, or cryptic language. This case does not involve elephants in mouse holes. This case instead involves an elephant, tariffs, in a statutory elephant hole, the power to regulate importation to deal with foreign threats in national emergencies. IEPA was a major and thoroughly studied statute carefully crafted to grant the president a suite of powerful tools, including to regulate importation and thereby allow him to respond swiftly to national emergencies and to help America respond to crises. Since its enactment, presidents have invoked IEPA more than 70 times to deal with emergencies and threats, from the September 11, 2001 Al-Qaeda attacks to Iran, to North Korea, and many others. By 1977, moreover, it was well known that tariffs on foreign imports, along with even more powerful tools such as quotas and embargoes, were a common way to regulate importation. IEPA thus bears zero resemblance to the paradigmatic, previously little used backwater statutory provision that cannot support significant executive actions. All of that makes this case dramatically different from, really the opposite of, the major questions cases where the court has ruled against the government. The text, the history, the context, and the precedent all point strongly to the conclusion that as of 1977, tariffs were a well-recognized means of regulating importation, like quotas and embargoes. As Judge Toronto persuasively summarized, this case bears none of the hallmarks of past major questions cases, where the court found a lack of clear congressional authorization for the government's asserted major power. IEPA's facial breadth in an emergency context makes the straightforward application of the statute's words hardly unheralded, and if a more specific herald is needed, it is present in the Nixon 1971 proclamation and subsequent congressional adoption of the relevant language in 1977. IEPA seeks to provide flexibility in the tools available to the President to address the unusual and extraordinary threats specified in a declared national emergency. This is not an ancillary, little-used backwater provision or a delegation outside the recipient's wheelhouse. This court's recent opinion in Biden v. Missouri strongly supports the President's position here. That case involved a challenge to President Biden's COVID-19 vaccine requirement for millions of healthcare workers. The executive action there, too, was undoubtedly major, but the court upheld the government's vaccine mandate based on a general statutory authorization for HHS to impose safety requirements for healthcare facilities, notwithstanding the lack of explicit statutory references to vaccines. In doing so, the court emphasized that state vaccination requirements were common for healthcare workers and that the federal government regularly required healthcare workers to take various safety precautions. Notably, the court upheld the vaccine mandate even though, as the dissenters pointed out, the federal government had not traditionally imposed such vaccine requirements on healthcare workers. The clarity of the congressional authorization in today's case is far stronger than in Biden v. Missouri. The Nixon and Ford tariffs, the Algonquin decision, and the president's longstanding authority to regulate trade and impose tariffs establish much more comprehensively and clearly than in Biden v. Missouri that the president is not claiming some unheralded power that represents a transformative expansion of his authority. Because the court upheld the executive's exercise of a major power in Biden v. Missouri, it follows that the court today should likewise uphold the president's assertion of a major power here. Like cases should be treated alike. In response to all of that, the Chief Justice's opinion clings to its primary argument in this case, that a statute must use the word tariff or duty or tax or the like to authorize tariffs on foreign imports. But the court has repeatedly emphasized that the major questions doctrine is not a magic words requirement. The Chief Justice's opinion identifies no case that has demanded such specificity, and in Algonquin, this court unanimously and squarely rejected the same argument that the statutory provision must specifically mention tariffs or duties or taxes for the president to impose tariffs on foreign imports. Under the Chief Justice's opinion, the Nixon and Ford tariffs would also have been unlawful. So too might other tariffs imposed under the long-standing Section 232 tariff statute, which broadly authorizes the president to adjust the imports of a foreign good without mentioning tariffs or taxes, and so would tariffs imposed in wartime under TWE's authority to regulate importation. The Chief Justice's opinion's approach to the major questions doctrine is a magic words test under another name, in contravention of our precedents that make it clear that Congress needs not use magic words or highly specific terms. In previous cases, the court has looked at the four factors to determine whether there is clear congressional authorization, precisely because the major questions canon has no magic words requirement. If magic words or the equivalent were necessary, that would be the only factor, and the court would not need the four factors that the court has consistently applied. In sum, under the major questions doctrine, as the court has applied it, this should be a straightforward case. Congress applied clear authorization for the president to impose tariffs under IEPA. Second, there is an alternative and independent reason why the major questions doctrine does not apply here. This is a foreign affairs case. A plethora of statutes in the U.S. Code grant the executive the power to act in foreign affairs, and most of the important actions that presidents take today, including in foreign affairs, rest at least in part on statutory authorization. Yet this court has never before applied the major questions doctrine or anything resembling it to a foreign affairs statute. I would not make this case the first. Rather, in the foreign affairs context, this court has interpreted statutes as written with respect for the primacy of Congress's and the President's rules in foreign affairs and without using the major questions doctrine as a thumb on the scale against the President. That deeply rooted textualist approach to interpreting foreign affairs statutes is nothing new. What is new and rather extraordinary is the approach embodied in the Chief Justice's opinion for 3 justices, which would extend the major questions doctrine into the foreign affairs realm for the first time. Recall that the major questions doctrine is based on 2 overlapping foundations: separation of powers principles and a practical understanding of legislative intent. With respect to separation of powers, the major questions doctrine serves to reinforce the non-delegation doctrine. But in the foreign affairs realm, the court has recognized that Congress often broadly delegates authority to the executive. From the founding, numerous foreign affairs statutes authorizing action by the president in respect of subjects affecting foreign relations either leave the exercise of the power to his unrestricted judgment or provide a standard far more general than that which has always been considered requisite with regard to domestic affairs. The reason for those broad delegations is simple and obvious. If success for America's foreign affairs aims is to be achieved, congressional legislation must often accord to the president a degree of discretion and freedom from statutory restriction which would not be admissible were domestic affairs alone involved. Stated otherwise, Congress, in giving the executive authority over matters of foreign affairs, must of necessity paint with a brush broader than that it customarily wields in domestic areas. As Justice Robert Jackson summarized, the court's non-delegation cases, consistent with the unbroken legislative practice which has prevailed almost from the inception of the national government, have recognized internal and external affairs as being in separate categories, and held that the strict limitation upon congressional delegations of power to the president over internal affairs does not apply with respect to delegations of power in external affairs. As Justice Jackson further noted, the court's precedents recognize the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the president is to be governed. If the major questions doctrine is designed in part to protect non-delegation principles, but the non-delegation doctrine does not play a substantial role in foreign affairs cases, as the court has held, then it follows that courts should not employ the major questions doctrine to put a thumb on the scale against the president when interpreting foreign affairs statutes. Rather, as Justice Robert Jackson stated, courts should interpret those statutes as written. Relatedly, to the extent that the major questions doctrine is designed to reflect a practical understanding of legislative intent, the doctrine appropriately plays no role in national security or foreign policy contexts because the canon does not reflect ordinary congressional intent in those areas. In the foreign affairs realm, Congress has good reason to and intends to authorize many executive branch actions related to foreign affairs in broad or general terms. Congress ordinarily seeks to give the president substantial authority and flexibility to protect America and the American people. After all, the president exercised the vast share of responsibility for the conduct of our foreign relations. So Congress often gives the president a degree of discretion. That unbroken legislative practice from the founding means that courts interpreting statutes in the foreign affairs field should assume that Congress meant what it said. Stated otherwise, if the major questions doctrine turns on a contextual inquiry into likely congressional intent, it likely for a variety of reasons to have less purchase in the foreign affairs area. To be clear, Congress, of course, maintains the ultimate power over how broadly or narrowly to write statutes in the foreign policy and national security context. For example, Congress can write foreign affairs statutes narrowly. Indeed, even for wartime powers, Congress rarely gives the president a blank check. And when Congress writes a narrow foreign affairs statute, this court has enforced those statutory limits as written. Moreover, when it does legislate more broadly, Congress sometimes claws back the statutory authorization by rescinding or amending overbroad statutes or by restricting previously granted presidential power through the leverage it possesses over appropriations, new legislation, or confirmations. Either House of Congress alone, through the appropriations process, can insist on certain limits as a condition of approving funding. At the end of the day, given the appropriations power, Congress holds the cards. In short, in the foreign affairs context, this court has never before superimposed the major questions doctrine or any similar canon or principle onto ordinary statutory interpretation to place a thumb on the scale against the president. Rather, the court interprets the relevant statutes according to their text, with respect to Congress's and the president's central role in the foreign policy and national security fields. This tariff case plainly falls into the foreign affairs category. IEPA directly and expressly relates to foreign affairs. IEPA directly and expressly relates to foreign affairs. And like quotas and embargoes, tariffs regulate the goods that are imported into the country from foreign nations. The tariffs do not apply to goods produced in America. Moreover, tariffs on foreign imports are significant tools of foreign policy and national security, whether imposed under IEPA, TWE, Section 232, Section 122, Section 201, Section 301, or Section 338. They are often used to advance foreign policy goals or as negotiating leverage in trade negotiations. Like other economic tools, tariffs can serve as a bargaining chip to be used by the president when dealing with a hostile country, or to incentivize a change in behavior by allies, partners, or enemies. With respect to foreign trade specifically, Congress often invests the president with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Since the founding, that long-standing practice has included tariff statutes. Congress has granted the president expansive power over tariffs and foreign trade, and this court has uniformly rejected challenges to tariffs imposed by presidents under those statutory authorities. As Professor Bradley and Goldsmith well summarized, there is a settled practice of about a century of the executive branch exercising emergency powers in many important contexts pursuant to the broadly worded IEPA and its predecessor, the Trading with the Enemies Act. And there is an even longer practice dating to the founding of presidents exercising trade-related sanctions authority pursuant to broadly worded statutes. Notably, the court has already suggested in both of these contexts that one should expect Congress to, in effect, paint with a broad brush. As with tariffs on foreign imports historically, the IEPA tariffs on foreign imports at issue in this case implicate foreign affairs. According to the government, the president has leveraged the IEPA tariffs into trade deals with major trading partners, including China, the United Kingdom, and Japan, among other countries. The government says that the tariffs have helped make certain foreign markets more accessible to American businesses and have contributed to trade deals with foreign nations worth trillions of dollars. Moreover, consistent with history and the traditional use of tariffs, the president is exercising his IEPA authority in connection with highly sensitive negotiations he is conducting to end the conflict between the Russian Federation and Ukraine. To that end, on August 6, 2025, the president imposed tariffs on India for directly or indirectly importing Russian Federation oil. And on February 6, 2026, the president reduced the tariffs on India because, according to the government, India had committed to stop directly or indirectly importing Russian Federation oil. To be sure, most foreign affairs and national security actions, whether war, international agreements, trade deals, or tariffs, lead to significant domestic ramifications within the United States, and this case is no exception. Nonetheless, in the foreign affairs field, courts interpret statutes as written with appropriate respects to Congress and the president and without a major questions doctrine. Without a major questions doctrine weight on the scale against the president. Lest there be any remaining doubt that the major questions doctrine does not apply to tariffs on foreign imports, recall again this court's decision in Algonquin. That case involved significant tariffs imposed by President Ford on oil imports. The relevant statute granting the president the authority to adjust the imports. The relevant statute granted the president the authority to adjust the imports. The court upheld the tariffs by interpreting the statute as written. Neither the major questions doctrine nor anything resembling that doctrine played a role in that case. In short, presidential actions pursuant to broad congressional authorizations related to foreign affairs often have long historical pedigrees that can in various ways inform congressional intent to approve the actions in question. To the extent that this is so in particular instances, the major questions doctrine's clear authorization requirement does not apply. So it is here. Presidents have long been granted substantial discretion over tariffs. This court has never before applied the major questions doctrine to a statute authorizing the president to take action with respect to foreign affairs in general or tariffs in particular, and it should not do so today. The Chief Justice's opinion reliance on the major questions doctrine in this foreign affairs case is a first, a novel and unprecedented use of the major questions doctrine to invalidate presidential action taken pursuant to congressional authorization in a foreign affairs area. I firmly disagree with that use of the major questions doctrine here. In the foreign affairs context, including tariffs, the longstanding rule is simple. Interpret the statute as written, not with a thumb on the scale against the president. Relating precedent further demonstrates that the major questions doctrine has not traditionally applied in the national security or foreign policy context. Consider two prominent examples. First, in Hamdi v. Rumsfeld, this court considered the 2001 authorization for use of military force, which Congress passed and George W. Bush signed on September 18, 2001, in the wake of the al-Qaeda attacks on the United States. The law broadly empowered the president to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th. In Hamdi, the government militarily detained in the United States an American citizen who had taken up arms with the Taliban. The plaintiff Hamdi argued, among other things, that the AUMF generally authorized the use of force, but did not specifically authorize military detention, at least detention of American citizen enemy combatants in the United States. He contended that his military detention was therefore illegal. In the principal opinion by Justice O'Connor, the court rejected Hamdi's statutory argument, explaining that it was of no matter that the AUMF does not use specific language of detention. Rather, because detention to prevent a combatant's return to the battlefield is a fundamental incident of waging war. In permitting the use of necessary and appropriate force, Congress has clearly and unmistakably authorized detention in the narrow circumstances considered here. Consider the similarities between Hamdi and this case. Both involve major questions of foreign affairs. Hamdi involved U.S. military detention of an American citizen in America pursuant to a generally worded authorization for use of military force. This case involves tariffs on foreign goods imported into America pursuant to a generally worded authorization to regulate importation. Detention is a traditional incident of the president's delegated power to wage war. Tariffs are a traditional incident of the president's delegated power to regulate imports and foreign commerce. In Hamdi, the court said that as a matter of history, practice, and precedent, the AUMF's general authorization for the use of military force clearly encompasses detention of enemy combatants. Here, as a matter of history, practice, and precedent, IEPA's general authorization for regulation of importation likewise clearly encompasses tariffs on foreign imports. Second, in 1981, in Dames and Moore, the court did not apply the major questions doctrine, even though the court had recently applied that principle in a significant domestic policy dispute, or a significant policy case. Blech. Second, in 1981, in Dames and Moore, the court did not apply the major questions doctrine, even though the court had recently applied that principle in a significant domestic policy case. The Dames and Moore case arose in the wake of the Iran hostage crisis, where Iran held more than 50 American hostages at the U.S. Embassy in Iran for more than 14 months. At one point, as one part of the ultimate settlement of the hostage crisis with Iran, President Reagan suspended claims by U.S. nationals against Iran that were pending in American courts. The president did so under IEPA and the Hostage Act. There can be little doubt that the question of suspending American citizens' claims against Iran was one of major economic and political significance. And the court further recognized that the case touched fundamentally upon the manner in which our republic is to be governed. Yet the court did not require clear congressional authorization for the president's exercise of that authority to suspend the Americans' claims against Iran. On the contrary, the court openly acknowledged that the relevant statutes, IEPA and the Hostage Act, did not provide clear or specific authorization for the president to suspend those claims. The court nonetheless concluded that the general tenor of Congress's legislation in this area, combined with Congress's longstanding acquiescence to the president's practice the president's practice of settled claims. Supported the president's suspension of those claims. Congress's general tenor and acquiescence are, of course, far less than the clear congressional authorization that the Chief Justice opinion today newly demands for the president's tariffs. Again, consider the similarities between Dames and Moore in this case. Dames and Moore involved complicated questions of foreign policy and national security. The statutes in Dames and Moore were generally worded and did not specifically authorize suspension of claims, but presidents had historically exercised a similar power. Here, we likewise have a generally worded statutory authorization to regulate importation, and presidents have historically imposed tariffs. If IEPA permitted the president to lawfully suspend claims in Dames and Moore, despite the court's transparent acknowledgement that the actual statutory text did not clearly authorize the president's actions, then surely IEPA's authorization to regulate importation easily justifies these tariffs. The Chief Justice's opinion would chart a new course for the major questions doctrine, extending it for the first time deep into the foreign affairs sphere. If the court had applied the major questions doctrine in Hamdi and Dames and Moore, those two landmark cases almost certainly would have been decided differently. So today's opinion marks a significant change. Will the court apply the major questions doctrine in the foreign affairs context again in the future, or is this a ticket good for one day and one train only? Time will tell. But in the meantime, the decision could engender significant uncertainty over the executive's exercise of statutory authority in the foreign affairs realm. As the Hamdi and Dames and Moore examples demonstrate, applying the major questions doctrine in the foreign policy and national security context in the past would have seriously hindered the president's ability to exercise power granted by Congress to achieve important foreign policy and national security objectives for America. And if applied in the foreign affairs context in the future, it could impair president's vital statutory authorities with respect to foreign policy and national security. Having said all of that on foreign affairs, I reiterate that the major questions doctrine, even if it applies in this foreign affairs context, does not defeat major executive actions that are clearly authorized by Congress. And as explained in Part 3A above, in IEPA, Congress clearly authorized the president to impose tariffs to regulate importation in national emergencies. In other words, even if the major questions doctrine applies in the foreign affairs context exactly as it does in domestic affairs, the president should still prevail in this case. Finally, no member of the court today relies on the non-delegation doctrine, but the plaintiffs briefly raised such an argument, and I will therefore briefly address it. The argument is unavailing for many of the reasons already noted in the major questions analysis above. This court has repeatedly rejected constitutional challenges to congressional delegations to the president and in the foreign affairs area, including delegations of tariff authority. For matters of foreign affairs and national security, the court has traditionally recognized that Congress must of necessity paint with a brush broader than that in customarily wields in domestic areas. For matters of foreign affairs and national security, the court has traditionally recognized that Congress must of necessity paint with a brush broader than that it customarily wields in domestic areas. And to reiterate, numerous statutes authorizing actions by the president in respect of subjects affecting foreign relations either leave the exercise of the power to his unrestricted judgment or provide a standard far more general than that which has always been considered requisite with regard to domestic affairs. Therefore, as Justice Thomas has explained, the court's precedents established that the Constitution grants the president a greater measure of discretion in the realm of foreign relations. Justice Robert Jackson likewise noted the unwisdom of requiring Congress in this field of governmental power to lay down narrowly definite standards by which the president is to be governed. As such, the strict limitation upon congressional delegations of power to the president over internal affairs does not apply with respect to delegations of power in external affairs. Because statutes that involve the external relations of the United States do not trigger the same kind of delegation concerns as purely domestic ones, the court has regularly upheld delegations of power to the president in the national security and foreign policy realms. Indeed, if a strict non-delegation doctrine applied in those areas, numerous statutes, including many authorizations for use of military force in the nation's history, would have been unconstitutional delegations of authority to the president. As to tariffs in particular, broad delegations of tariff authority to the president have been in the heartland of permissible delegations upheld by this court. Congress may, without running afoul of the Constitution, invest the president with large discretion in matters arising out of the execution of statutes relating to trade and commerce with other nations. Congressional delegations of tariffs and other foreign trade authorities to the president date back to near the founding, and this court has uniformly rejected non-delegation challenges to statutes delegating that authority to the president. This court's decision in Algonquin is again instructive. There, the court held that Section 232 did not constitute an unconstitutional delegation. The court found it sufficient that the president could act only to the extent that he deems necessary to adjust the imports of an article such that it will not threaten to impair the national security. To be clear, I am not suggesting that there is no non-delegation doctrine in the foreign affairs realm, but the court has consistently recognized that the doctrine affords more flexibility to Congress and the president in that area to deal with complex foreign relations issues and national security threats facing America. In all events, for purposes of this court's non-delegation precedents, IEPA sufficiently constrains the president's authority to declare an emergency and impose tariffs. The president may exercise the authorities in IEPA only to deal with an unusual and extraordinary threat that has its source in whole or substantial part outside the United States, and with respect to which a national emergency has been declared. Congress placed numerous limits on IEPA, including a default one-year time limit, an enumerated list of exceptions, and comprehensive congressional reporting requirements. It is also useful to underscore the extraordinary nature of the plaintiff's non-delegation argument here. The plaintiff's submission would mean that these tariffs would be unlawful even if IEPA explicitly authorized tariffs. Unlike their statutory and major questions doctrine arguments, their non-delegation arguments is not based on a lack of an explicit reference to tariffs or duties or the like. Their non-delegation argument instead goes much further and would require very specific congressional directions to the president on when and under what circumstances he could impose tariffs and how high those tariffs could be. The plaintiff's theory would have dramatic consequences and likely wipe out many of the existing tariff statutes that have long been upheld by this court, as well as TWE. And if the tariff authority here is unlawful, so too are most, if not all, IEPA authorities, such as asset freezes, embargoes, and quotas. And it would not stop there. The plaintiff's non-delegation theory would threaten various other national security and foreign affairs statutes that similarly grant substantial discretion to the president. The court today, thankfully, does not go down that road. The overarching theme of the court's opinion is that tariffs are not a clear means to regulate importation, and that Congress was therefore required to use the word tariff, duty, or the like in IEPA in 1977 if it wanted to authorize tariffs on foreign imports. But that conclusion contravenes text, history, and precedent. To summarize Algonquin, in 1976 unanimously upheld the opposite. The Nixon and Ford tariffs were based on statutory provisions that did not use the word tariff or duty. There is a long tradition of presidents imposing tariffs as a means of regulating importation and commerce. The predecessor Trading with the Enemies Act has long been understood to authorize tariffs during wartime as a means to regulate importation, even though it does not use the word tariff or duty. The history of the Polk, Lincoln, and McKinley tariffs shows that tariffs are a means of regulating importation. Marshall's story in Madison stated that tariffs are a means of regulating foreign commerce. The dictionary definitions of ordinary usage establish that tariffs are a means of regulating importation. All of that and much more, in my view, overwhelmingly establish that IEPA clearly authorizes the president to impose tariffs. That said, with respect to tariffs in particular, the court's decision might not prevent presidents from imposing most, if not all, of these same sorts of tariffs under other statutory authorities. For example, Section 122 of the Trade Act of 1974 permits the president to impose a temporary import surcharge to deal with large and serious United States balance of payment deficits. Section 201 of the Trade Act of 1974 provides that if the International Trade Commission determines an article is being imported in such quantities that it is a substantial cause of serious injury or the threat thereof to the domestic industry producing an article like or directly competitive with the imported article, the President may take appropriate and feasible action, including imposing a duty. Section 301 of the Trade Act of 1974 authorizes the President, through a subordinate officer, to impose duties that if he determines that an act, policy, or practice of a foreign country is unjustifiable and burdens or restricts United States commerce. Section 338 of the Tariff Act of 1930 permits the President to impose tariffs when he finds that any foreign country places any burden or disadvantage upon the commerce of the United States. And Section 232 of the Trade Expansion Act of 1962 authorizes the President to, after receiving a report from the Secretary of Commerce, adjust the imports of an article and its derivatives so that such imports will not threaten to impair the national security. So the court's decision is not likely to greatly restrict presidential tariff authority going forward, but the court's decision is likely to generate other serious practical consequences in the near term. One issue will be refunds. Refunds of billions of dollars would have significant consequences for the U.S. Treasury. The court says nothing today about whether, and if so how, the government should go about returning the billions of dollars that it has collected from importers. But that process is likely to be a mess, as was acknowledged at oral argument. A second issue is the decision's effect on the current trade deals. Because IEPA's tariffs have helped facilitate trade deals worth trillions of dollars, including with foreign nations from China to the United Kingdom to Japan, the court's decision could generate uncertainty regarding various trade agreements. That process, too, could be difficult. The tariffs at issue here may or may not be wise policy, but as a matter of text, history, and precedent, they are clearly lawful. I respectfully dissent. Whew. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop it in the comments and I'd be happy to take a look. Thank you.